I now have the pleasure of introducing our speakers for today. We do have a few speakers for our roundtable discussion. We, of course, have back with us, so welcome back, Margret McGladrey, who received her doctorate in sociology from the University of Kentucky and completed a postdoctoral fellowship in civic studies at Tufts University. Dr. McGladrey is a research assistant professor with the Center for Innovation in Population Health and serves as the criminal legal system faculty co-lead for the Healing Community Study, Kentucky. She has expertise in community engagement and participatory research, as well as quality improvement and program evaluation in complex systems of care. And we also have back for this week Susannah Stitzer, who's the project director for the criminal legal systems team at the Healing Community Study at the University of Kentucky. Ms. Stitzer earned her JD at the University of Kentucky College of Law and her MPA at the Martin School of Public Policy Administration. Prior to joining HCS, Ms. Stitzer managed an interdisciplinary neuroscience research program at the University of Kentucky. And then we also have three new additions to our panel today. The first is Aaron Trosper, who is in long-term recovery and joined Voices of Hope in November of 2021 as a recovery coach. During this time, he was a floater and had the opportunity to go to many different linkage and retention settings while helping others sustain a pathway to recovery. Aaron had the opportunity to work with Madison County Detention Center, and with Voices of Hope and Madison County Detention Center teaming up, Aaron was able to distribute over 1,250 units of Narcan throughout the jail and educated over 130 participants about different pathways of recovery. He was then promoted to a lead recovery coach, helping new employees learn and convey MAD flyers, scheduling, and supporting his peers as they establish positions within each agency. Following his work as a lead recovery coach, Aaron was promoted to program coordinator for outlying counties regarding Wave 1 sustainability. We also have with us today Gary Biggers, who is a person in long-term recovery and first came to Voices of Hope to attend mutual aid meetings. In March 2021, Gary began his employment with Voices of Hope as a recovery coach deployed at Fayette County Specialty Court. Following his work as a recovery coach, Gary was promoted to lead recovery coach and now occupies a role of criminal legal systems program coordinator for Wave 2 of the Healing Community Study. Gary has contributed to academic presentations on linkage and retention programs and frequently collaborates with Dr. Lochwall to prepare and evaluate all Voices of Hope Hill recovery coaches on their knowledge of medication for opioid use disorder. And then finally, we have with us Rebecca Gray, who is a person in long-term recovery and began her employment with Voices of Hope in February of 2023. Rebecca works as a recovery coach deployed in Wave 2 of the Healing Community Study. Rebecca's placement is at Knox County Detention Center and allows her to make contact with individuals at various stages of their involvement in the criminal legal system. Rebecca provides one-on-one peer support sessions with inmates, as well as weekly SMART recovery meetings. Rebecca has access to barrier relief funds to help ease the financial burden of individuals leaving incarceration who are seeking medical treatment for opioid use disorder. So welcome to all of our speakers today. We thank you so much for being here, and we're excited for your presentation for us today. I will turn it over, the slides over now to Dr. McGladrey to go through them, but I did just want to make sure I shared this financial disclosure slide before I did so to ensure that we shared that there were no financial relationships to disclose.
So yes, thanks again for having us. It's a real pleasure to be here with our Voices colleagues and with Susannah and I, as we did last time, where we're going to be talking about different elements. The pattern that we'll take is I'll be introducing and talking about different elements of the criminal legal system from a structural and policy perspective. And then Susannah, as our implementation queen, our project director for the criminal legal system team, will talk about the ways that we've actually applied our evidence-based practices around linkage and retention and medication treatment in the criminal legal system team. And another thing that I want to note here at the beginning here is, as Chris said, we had 6 great questions come in between the sessions here. So we'll be answering those questions throughout the session. Susannah and I have gone through and integrated them into the structure of the presentation. So right at off the top here, we got a question that individuals previously received pretrial services within the past 5 years are eligible to receive it again. And someone had asked, given that substance use disorders are a chronic condition, has there been any discussion to change those criteria? Again, the question was about pretrial services not being eligible to receive those services after 5 years. And for whoever asked that question, I'm sorry about that misunderstanding, but there's no eligibility cutoff for pretrial services. AOC's pretrial services specialists are required to conduct interviews and risk assessments for everyone as part of the booking process, but they don't provide support services aside from the monitor and conditional release and collaboration with defense attorneys on misdemeanor diversions that we talked a bit about last time. And I'll just add something to everybody's thinking here. If there was another program that the questioner could have been thinking of, please feel free to either put that question out in the chat or direct it to Chris, and he'll make sure that we can follow up on that at that point. If there was another program that you had heard us talk about with 5 years of eligibility limitations there. So just wanted to clarify that. And there was another good question. Let me check the chat here. Yes, thanks, Mike. Administrative Office of the Courts, that's right. So another question that we got right here off the top, what has been the most effective way to coordinate care between the criminal legal system and substance use treatment providers? So that's really what this session today is all about. So we hope that this whole session will be an answer to that particular question. So just as a reminder here of the practice gap and educational needs, learning objectives, and expected outcomes for our session together today. As we pointed out last time, the Kentucky Department of Corrections is the largest provider of substance use disorder treatment services, which is a pretty astounding overlap between public safety and public health in and of itself. But behavioral health providers often lack training on how criminal legal system involvement affects clients' ability to participate in treatment and services. So it's really critical to understand how involvement in the criminal legal system, or CLS, can be reduced through diversion to treatment, as well as the complications with providing services to people in government custody. So our learning objectives are to explain SAMHSA's sequential intercept mapping approach and the 6 intercept points where people involved with the criminal legal system can be engaged in overdose prevention and SUD treatment. Last week, we went through the overdose prevention and naloxone distribution applications to those 6 intercept points. And this week, we're focusing on linkage and retention and MOUD treatment at those 6 intercept points. We'll describe best practices for implementing overdose education and reduction strategies in the criminal legal system from the HCS Kentucky experience. And we'll recognize and talk about the respective roles of alternative sentencing workers, social service clinicians, and other practitioners in facilitating treatment and providing overdose prevention resources for people involved with the CLS. So we hope that you'll take away from both of these sessions understanding of how the CLS process and roles affect SUD prevention and treatment in Kentucky, and enhance your understanding of the collaboration and communication environment for serving people involved in the CLS and behavioral health treatment, and how to adapt to these complications in practice, which our Voices of Hope colleagues are absolute pros at, as you'll hear. So for those of you in the room here who actually deliver these kinds of services, this will be a recap, and I'm sure you could explain it even better than I can here. But really what we're seeking to do with our linkage and retention programs, Menu 2 and HCS Speak, with our MOUD strategies for the Healing Community Study, is to provide individuals with support in navigating their recovery journey. So linkage services focus on providing education about MOUD and other treatment options and addressing barriers as individuals identify their best recovery path. Retention services are for individuals already engaged or having completed a treatment program. And we have 2 partners with HCS who have helped us with implementing linkage and retention programs. The Bluegrass Care Navigators, who are more clinically oriented and case management focused as either nurses or social workers, and then Voices of Hope, peer supports who walk alongside participants as recovery coaches. And at this point, I want to address another question that came up between our sessions. Someone had asked, would hiring more jail staff with a social worker background be the answer to reducing barriers and stigma? Has this been done in the USA? Has there been any studies to demonstrate the benefit to hiring social workers? So an important point here is that HCS has placed 1 social worker with BCN, who is currently in LMDC San Bernardino, and she'd worked in Franklin County Regional Jail in Wave 1. But, and this is a really interesting point and kind of a practical limitation, insurance issues for BCN, their insurance carrier, prevented us from being able to hire additional social workers through BCN and place them into criminal legal system agencies because BCN's insurance company was concerned about legal issues, was concerned about the litigiousness of clients involved with the criminal legal system and coming back to the BCN with different kinds of complaints, right? So that's a kind of borderline discriminatory when you think about it, right? But that was a barrier that we faced. After we had the successful partnership with BCN in Wave 1, we were no longer able to work with BCN with new deployments in Wave 2, but we were able to place Sam, the social worker, and then Tasha, a nurse navigator, in Wave 2 because they became employees of UK. So one of those practical legal complications that makes it challenging for some of our agencies to be able to place social workers in these kinds of agencies. And I'm going to go ahead and put out in the chat here. I'm going to go off, reduce my screen share for a second here. And I'm going to put some links out in the chat to help answer some of our different questions that came up in this three-part question from last week. So first, I wanted to share with you all a link to a really nice history of the relationship between social work and corrections in the United States here. So that's a really nice resource for looking at kind of that overall collaboration. And then I'm going to put out in the chat here also, this person had asked about examples of evaluations of the impact of social work in reentry processes, and I'm including an example from the San Francisco Public Defender, so you can see some of the typical kinds of outcomes that we see associated with that. And then another article that I'll put out in the chat here for reference to answer this question goes into some of the challenges with integrating social workers into the criminal legal system environment. Specifically, it's talking about the prevalence of mental health disorders among correctional workers. And this is applicable to not just folks, correctional workers operating in that custodial role, but everyone working within a detention facility. This research, that third link I provided, finds that consistently higher rates of mental health disorders among correctional workers relative to the general public and other public safety groups. For example, in the state of Washington, James and Todak found correctional workers have PTSD prevalence equal to Iraq and Afghanistan veterans and more than police. In the Canadian context, Carlton Riccardelli et al. Have recently found that well over half of correctional workers in the Ontario Provincial Correctional Service frequently screen positive for mental health disorders, most frequently PTSD and major depressive disorder. Researchers also indicate correctional workers are likely at a higher risk of death by suicide. So I bring up these points to say that, I think the important point in answering this question is, with more jail staff with social backgrounds, social worker backgrounds be the answer to reducing barriers and stigma? There's certainly some benefits of this kind of support for social work support integrated into the reentry process, but we need to remember that just having a social work background isn't necessarily enough to transcend some of the pressures, the cognitive load pressures that often lead to stigma among professionals serving folks with mental health issues and substance use disorders. Social workers in the correctional context face those same kinds of pressures, mental health issues, and PTSD that other folks in different roles in the correctional facilities do. So we can't necessarily expect or hope that the social work background will transcend some of the structural issues in the facility unless we're doing big process and policy improvement things that we're going to be talking about here through our linkage program description. Okay, so just a little bit more context here on why is HCS focusing on MAUD linkage and retention programs. Of course, as many of you know from your own training and experience with this, our strongest scientific evidence supports the efficacy of medications to prevent overdose over other treatments. And of course, withdrawal and detoxification increases the risk of overdose and death. So this really points to, we talked a little bit last week, Susannah talked a little bit last week about the importance of providing OEND to folks at release because of decreased tolerance due to being weaned off of medications while in a correctional facility, re-entering the community, having decreased tolerance, and then being exposed to potentially more potent opioid analogs like fentanyl, for example, leading to higher rates of, so we think in Kentucky, the latest data we have is that folks who are leaving prisons and jails are 12.7 times more likely to overdose in the 2 weeks after being released from a correctional facility than folks in the general state population. There's another piece of the puzzle here around withdrawal and overdose death. So Susannah, again, talked last week about this increased risk of overdose after release. But MOUD access in jails is also critical because incarceration otherwise precipitates forced withdrawal or detoxification, which in jails often is treated only through comfort medications like Tylenol. So if you all remember, Dr. Anne-Marie South came and talked with you all on July 13th with the KY open session. As Dr. South discussed, denial of MOUD access by public agencies also is a violation of the Americans with Disabilities Act and has been successfully argued in court cases to constitute a violation of the 18th and the 14th Amendments. So I'd like to share an illustrative story that Dr. South writes about with Drs. Lothwell and Panucci in their recent Viewpoints article for the Journal of the American Medical Association. That kind of gives you a feel for the stresses and strains around withdrawal in the prison context. Mr. J is a man in his early 40s with severe opioid use disorder, OUD, who is incarcerated in a county jail shortly before being brought to the hospital for an injection-related infection. As is common for persons who are hospitalized while incarcerated, he was shackled to the bed with guards present. In jail, he had not been screened and treated for OUD using evidence-based medical practices, resulting in severe withdrawal in jail. He then required opioids for analgesia and withdrawal while hospitalized. Mr. J was interested in treatment with MOUD, and buprenorphine was initiated, which is the standard of care for treatment of OUD. Mr. J expressed gratitude for the medication. Buprenorphine relieved his pain and with opioid withdrawal symptoms, and it helped control his opioid cravings, as you see in the chart here describing the relative benefits. Mr. J received treatment for the infection with surgical management and prolonged intravenous antibiotics. His main concern was how he could continue MOUD treatment. The hospitalist contacted the jail physician, who confirmed that they had the medical qualifications to continue buprenorphine, but refused to do so, citing the county jail policy. MOUD is only prescribed for persons who are court ordered to receive it or who are pregnant and receiving MOUD prior to incarceration. Mr. J was devastated by the news. After shared decision-making with the patient, the hospitalist administered extended release buprenorphine or Sublocade, a long-acting monthly injection to provide MOUD treatment for as long as possible for his additional 60 days in jail. Extended release buprenorphine obviates the jail resources required for daily supervised dosing and mitigates the risk of misuse and diversion, which is a significant concern among jail administration. After discharge, the jail transported Mr. J to infectious disease and surgery follow-up appointments, but refused to transport for an addiction medicine appointment for the next extended release buprenorphine injection. So that case study, that story gives you a feel for some of the ways that interaction with these custodial processes affect adherence and retention in MOUD treatment and have some of these negative consequences with the experiences of withdrawal, unnecessary suffering. That's the 8th Amendment violation and the 14th Amendment violation around undue and unnecessary suffering that is caused as with the ADA violation, not providing MOUD to people who are incarcerated. So I'll turn it over to Susannah here to talk a little bit about how successful we've been with OEND and linkage to treatment with individuals in the pretrial system. Oh, this is actually me, Susannah. I'm sorry. Sorry, I didn't make this note here. I wanted to address this question before we kept moving on here to give you all a sense from the Q&A from last time around. Someone had asked how successful OEND and linkage to treatment have been with individuals in a pretrial system. So I've given you all our numbers here for HCS and naloxone distribution in wave 1 and wave 2, as well as our wave 1 and linkage retention numbers here. So we have not separated out the success of OEND and linkage specifically in a pretrial system because we are often working with folks, even if they come into our programs, linkage and retention, through a behavioral health care provider, they may still be involved with the criminal legal system in some way. It's just the referral site that determines that. So we don't separate our numbers in terms of who's a client who's been involved with the pretrial system, as opposed to incarcerated, as opposed to someone who's on probation and parole. But these numbers, I hope, give you a sense of the extent of the impact here. You can see the CLS distribution and naloxone distribution numbers here, but we would be happy to answer any questions, follow-up questions on the success of OEND and linkage to treatment with individuals in a pretrial system that folks might have as a follow-up at the end. So now I'll turn it over to Susannah.
Thank you, Margaret. Minor moment of panic there. So as you may recall this graphic from last week, we talked about the previous session took Kentucky's total incarceration rate of 930 per 100,000 people. And how if you treat Kentucky as an independent entity, it would rank 7th in the world in incarceration. What I'd like to talk about today is some additional context around that incarceration rate, including who and what helps keeps those rates so high. Not only does Kentucky's rate exceptionally high, it's continued to grow as many other states have made reforms to reduce incarceration. From the 10-year period from 2008 to 2018, while the overall US had a reduction of 8.5% in their state prison population, Kentucky's increased by more than 11%. In 2011, the state passed a significant criminal legal system reform bill aimed at reducing incarcerations. But since then, the General Assembly has enacted 76 laws increasing incarceration and only 14 reducing it. In the most recent 2023 legislative session, the Kentucky legislature passed 5 bills creating new felony offenses or increasing criminal penalties for existing felonies, including an expansion of death penalty eligibility, but only 2 bills reduced incarceration penalties. Contributing to the Kentucky's high incarceration rate are high rates of pretrial detention and individuals incarcerated for supervision violations. An estimated 43% of Kentucky's jail population is detained while awaiting trial, meaning they haven't been sentenced. There are pending charges, but no adjudication has been made. In many cases, these defendants are held simply because they can't meet the terms of their bond. Less than 40% of both financial and non-financial bonds set in Kentucky result in pretrial release. Of the prison population represented here, that's just limited to your state and federal populations, approximately 45% are incarcerated due to supervision violations, most of which are technical violations, which are non-compliant but non-criminal behaviors like missing a meeting with their parole officer. Make this point to just understand that there are a large number of individuals who are incarcerated pending charges, awaiting other service, or sort of in a purgatory state. They shouldn't necessarily be here, or there are perhaps alternative methods to which we could divert their sentences. Moving to the next slide, we also talked about the interplay of co-occurring medical conditions and justice-involved persons. In the US, we estimate an 80 to 85% of incarcerated persons have substance use disorder. And in Kentucky, an estimated 45% have a mental health disorder. We talked about how individuals with co-occurring substance use disorder and serious mental illness are overrepresented in every part of the criminal legal system and are more likely to be arrested, booked, convicted, and incarcerated than only those with one or other disorders or neither. But if we focus in specifically on individuals with opioid use disorder, a 2019 Bureau of Justice Statistics report found only a quarter of Kentucky jails provided continuation or initiation of MOUD. That same report found that despite a positivity rate of nearly 20% in jail OUD screenings, only 7% of the population was treated for withdrawal, and a 0.4, less than 0.5%, received MAT. I do want to note, because I realize sometimes our data paints a bit of a bleak picture, that things are improving. The Department of Corrections has instituted a pilot program, Supportive Assistance with Medication Addiction Treatment, or SAMAT, at 14 state facilities and 18 local jails, providing MOUD to eligible participants. Importantly, their early data indicates that intervention is working. Among the 81% of participants reporting opioid use within the 30 days prior to incarceration, only reported 30 use at 6-month follow-up, and none had experienced an overdose. The Kentucky Judicial Commission on Mental Health is also making great strides. Established by the Kentucky Supreme Court in 2022, the commission is charged with exploring, recommending, and implementing transformational changes to improve system-wide responses to justice-involved individuals experience mental health needs, substance, and intellectual developmental disabilities. While their work is still in its infancy, it's gaining traction as other statewide agencies like pretrial services and specialty courts have undergoing complementary efforts, helping to accelerate process throughout the state. As Margaret's mentioned, the sequential intercept match are being used as a tool for the commission to help guide and identify increased and improved intervention resources across the system. And at HCS, we've had the fortunate experience of experiencing firsthand how many efforts are taking place at the local and county levels to increase awareness and acceptance of MOUD. So we know that there is a lot of positive change happening at multiple levels. This brings us back to HCS and how we've implemented recovery resources across the spectrum. Again, here's the simplified sequential intercept map demonstrating the points at which we can intervene to identify and provide services to people with OUD, as well as for other mental health and substance use needs. The chart above, as you'll recall, is color coordinated to the graphic and indicates the points as which we were able to implement both OEND and MOUD strategies across the CLS system. In the previous session, we reviewed implementation of OEND in law enforcement agencies, pretrial services, county jails and home incarceration programs, specialty courts, and probation and parole. This week's focus, medications for opioid use disorder strategies, were implemented in jails, specialty courts, and probation and parole. You'll notice that's a narrower pool of agencies than with OEND. That's largely because of practicality considerations. Recovery services are provided one-on-one on an iterative basis, and not all CLS settings have the infrastructure that readily enables initiating or supporting that level of engagement. In just a minute, you'll hear from me again with a brief overview of the adjudication process, but I believe Margaret is going to lead us off with a quick poll first.
Yes, I'm going to go ahead and pull up the poll here to get you all thinking a little bit about some of the ways that the pretrial system is impacting folks from a social determinants of health perspective. I need to share the results of the last poll here, and I'll stop sharing those. Let me go back to. Okay, so you all should see a poll with 3 questions here. Approximately what % of all the people who are incarcerated in the U.S. City and county jails have not yet been sentenced or been found guilty of any crimes? And then got a double-barreled question here. Approximately what % of women who can't afford bail have minor age children? And then third, the average yearly income of a woman who can't afford bail is what? Thinking about what these questions mean for access to resources and recovery capital for those folks who are not sentenced, not found guilty of any crimes, but incarcerated with bail terms they can't afford. That would mean if they were also dealing with substance use disorder. Give it just a minute more here for a few more answers to come in. We're almost to 100% participation. Thank you all so much. Okay, let's go ahead and end the poll. We'll share the results and I'll share the answer. So hopefully folks can see the answer here. We had the majority of people voting for the 59% option for question number 1. The correct answer, according to the Prison Policy Institute, is actually 69% across U.S. city and county jails have not yet been found sentenced. And some of this, as Susannah said, is due to bail bond kinds of conditions. Also, after the pandemic, a lot of our dockets, our court dockets, got really backed up, and you're going to see how complicated that adjudication process is with Susannah's next point here. So with those dockets getting backed up, there's more people who are not able to bail or bond out of pretrial detention. They stay incarcerated for longer, waiting for those sentencing hearings. For question number 2, our correct answer is folks were definitely on that higher end, which is the correct range here, but it's actually 66%. 66% of women who can't afford bail have minor age children. So thinking about that intersection between incarceration and family dynamics. And then for our last question here, what is the average annual yearly income of a woman who can't afford bail? Is $11,000. So imagining what that would feel and look like to be making those different kinds of choiceless choices there. Thank you all so much for participating. So I'll take it over to Susannah, who as a JD is uniquely equipped to guide us through the adjudication process and some of those. So you'll be able to really get a sense of those complications, why there would be that kind of backlog in terms of the court dockets.
Thank you, Margaret. So as noted, we've discussed the points of intervention, but less about what the process looks like to the individual experiencing it. As you can see from the different diagrams on the right depicting the adjudication process, various sort of diagrammatic walkthroughs, it's a really complicated path, and there are multiple points of deviation. At different hearings and motions, different decisions can be made and diversion treatments approached. But as a general term, the process goes something along these lines. An individual is arrested and processed. They then have a bond hearing where it's determined if they can be released pending the outcome of their charges. If bond is set and that the individual can afford the fees, then they're released. If bond isn't allowed or the individual can't afford the fees, then they're held in jail pending the outcome of their case. Their case then proceeds through the arraignment process and the sequential judicial and court processes. There are pretrial hearings and motions, after which the case can go to trial, a whole other time-intensive process in itself, or parties can agree to a plea deal, or the case may be dismissed. However, once that determination is made, sentencing, dismissal, or plea, it's the start of another process. They may have to go through probation and parole and adhere to the terms and requirements of that, often upwards of 2 years commitment following that time. They may need to proceed through the steps in a specialty court program, meeting the requirements of that program to successfully graduate. There are lots of ins and outs, and unfortunately, it's not a simple process, and the same path doesn't apply to everybody going through it. It sounds like a lot, and it is. It's a very time intensive. From the top of the slide, you'll see that the average time to disposition, that determination of sentencing, plea, or dismissal, is 193 days for district court cases, and that's primarily your misdemeanors and minor violations, and 256 days for circuit court cases, which are primarily felony charges. For persons that can't afford to be released or who aren't allowed to have bond set, that's 6 to 9 months in a jail without being sentenced. If they're housed in the 65% of Kentucky's jails that are over capacity and under resourced, that's 6 to 9 months without sentencing of overcrowded living conditions, 6 to 9 months of potentially unrecognized and untreated mental health and substance use disorders. So the question then becomes, how did HCS think about providing much needed resources and interventions across a complex system with variable processes? One of the key components was identifying and establishing relationships with partners already working to address these challenges. I'm going to turn it over to Margaret, who's going to discuss our relationship with the Department of Public Advocacy and their Alternative Sentencing Workers Program.
Thank you so much, Susannah. So something we talked about during the first session was that often with the criminal legal system, we have kind of a parallel process of treatment and services that run alongside the different kinds of criminal legal system roles. So as Susannah was saying, the Department of Public Advocacy or the public defenders, the parallel process that is helping defendants, and of course, a lot of the defendants we are working with Healing Community Study, are folks who are considered to be indigent and to have a public defender appointed to them, right? So they're working with a public defender. The parallel process person in Kentucky is called the Alternative Sentencing Worker. So the Alternative Sentencing Worker program was initiated in 2015 with Senate Bill 192, also known as the Heroin Bill. Thanks, Mike, for the acronyms. And the result of that Senate Bill 192, the Heroin Bill, was the placement of 37 ASWs, Alternative Sentencing Workers, across the state, at least one in each Department of Public Advocacy field office. So in a nutshell, what ASWs do is that they use motivational interviewing techniques to develop individualized treatment service plans or alternative sentencing plans with clients and public defenders following clients' expressed interest to present to the court in lieu of incarceration, allowing clients to be placed on supervised release and participate in community-based treatment. And this is expressed interest is important to distinguish between best interest from a legal perspective, because expressed interest is really going with, the ASW is going with what the client wants and putting together a plan that moves them toward their expressed interest, as opposed to the alternative sentencing workers' clinical, perhaps, a determination of what their best interests might be. So with the Healing Community Study, during Wave 1, we met with the state level ASW program supervisor and worked with Voices of Hope, Wave 1 jail placements and our BCN jail placements to develop coordination processes that will allow us to provide those recovery supports and help plan for folks to be linked to treatment as they're navigating all of these complicated steps, with the ASW serving as kind of that mediator or that connector between our recovery coaches and our navigators and the public defenders who are actually making the case in court here. So in addition to developing the alternative sentencing plans, which is their main area of practice, alternative sentencing workers act as an agent of the defense attorney with the same confidentiality agreements. They're conducting comprehensive assessment, making referrals, building rapport, and gaining clients' active decisions to participate. They also provide crisis intervention strategies, conduct baseline and 12-month follow-up interviews, facilitate collaboration between agencies, and create and update their own community resource guides, and provides more detailed information about community resources, services, and programs that they integrate into their alternative sentencing plans here. And another important point before I move on to the next slide here is that alternative sentencing workers have kind of a triage of priority cases where they are given the fact that they could be appointed by the defense attorneys to a lot of different kinds of cases. Given the limitations of caseload, they're typically focused on those felony probation, revocation, and other revocation types of hearings. So they're typically looking at those felony cases as opposed to the misdemeanor cases. And the misdemeanor cases are those ones where we can really make a difference because they're often things related to either directly to substance use disorder in terms of trafficking or possession of illegal substances, and or directly related through perhaps a property crime that could be tied to some form of addiction that was necessary, or like different kinds of trafficking charges. So a lot of the misdemeanor charges might be proxies or indicator of substance use disorder, but it might not rise to the level of a priority case for an alternative sentencing worker. So that's the perfect role for our Voices of Hope coaches and navigators here. And just another note here too about the alternative sentencing workers. They do also have Narcan kits within their trial offices, and they distribute them to high-risk clients. And clients at high risk they determine those as folks who have been released from jail, refusing treatment or without a planned treatment option. They make sure that those folks that they're working with are given naloxone units. So they have a naloxone program already in place. So I'll turn it over to Susannah to talk a little bit more about the process that we developed here for collaborating, again, focusing on participants charged with misdemeanors, with those carrying a potential sentence up to 12 months and often maybe indicative or proxies of substance use disorder due to the ASW's heavy felony caseload. Take it away, Susannah.
Thank you. As you'll see on the rest of that slide, actually, it gets into a lot of the details that go into consideration. And one of the things I want to take you away from the description of the ASW's work is there's a lot of overlap or potential for overlap between the ASW's work and what a coach or navigator placed in the jail is doing. Moreover, the work that recovery coaches and care navigators are doing to support participants as they consider and hopefully enter some form of treatment can directly impact their court case. An individual's interest in treatment, their commitment to a program, their ongoing recovery sessions, or even just the availability of a bed at a treatment center are all factors that their attorney, the prosecuting attorney, and the judge can take into consideration. In the inverse, knowing whether an individual is likely to be released in the foreseeable future, what charges they may have to face in other counties, or how the county judge views specific methods of treatment, all impact the coach or navigator's ability to approach treatment and how they provide support. To support that open communication and partnership, our jail place coaches and navigators have built relationships with the ASW to coordinate efforts and share information so that they can meet the best interests of the participant. In many cases, ASWs have also made referrals to the coach or navigator directly. And in wave two, we're able to sort of develop a relationship with our Jefferson County office and hopefully take a formalized process, and their team of ASWs will be referring directly to the coaches in Jefferson County. I'm going to turn it over to a minute to Aaron Schosper and Gary Biggers. Aaron was, as you know, in our Madison jail, which is often a frequent point of conversation. And he's going to share some information about the process of communication he established with the ASW and the larger partnership they built with additional partners in that space. Aaron?
Yeah, thanks, Suzanne. So as Margaret and Suzanne said, we would go in, and within the first 24 to 48 hours of someone being incarcerated, they would like for us at the jail to go in and talk with the person and see like what could best potentially help them identify ways of finding a pathway that might work for them, so they don't have to have reoccurring coming back to being incarcerated again and again. So like within 48 hours, when they go to see the judge, about 70% of people get released. So they would like for me to interact with these people and try to help. So part of my process was identifying if they had OUD or substance use disorder, right? So then at that process, I would have that interaction with them, and I would reach out to the ASW and say, hey, is this a person I can work with, or do you see any complications working with it? Because most of the time I'm trying to interact with people with misdemeanor cases, right? So there might be some ongoing cases or things that's building up. So they would say yes, no, or you need to hold off on this person. I'll let you know when you can interact or work with this person. So through that, there's been a few a few times that the ASW would contact me and be like, "Hey, can you find a treatment facility for this person? They're about to be released, and I can't really get nothing worked out for them." And they would tell me the guidelines of what they would want them to be in, right? So also the social service clinicians with the VCN, they were really great, because as I'm talking with them, as when I'm talking with a participant, I would discover like if they might have had dual diagnosis, like some mental health issues or anything like that they'd previously been diagnosed on. And if they did, that's when I would reach out to the VCNs and be like, "Hey, this person has a dual diagnosis. Is there any way that you can interact or come in and talk with this person?" And at that point, Madison County is very open to what we did within the jail. So I could bring in the VCN to speak with this person. There's a lot of times where I had the opportunity a person was about to be released, and it's hard to really get someone seen in the same day, so to speak. And it was like end of the day type things. And BCNs were able to work with these peers and get them seen, because they'd be withdrawing and having, they'd be withdrawing, going through a bad time where they haven't been using because they've been incarcerated for the last 24 to 48 hours. So that's when we would be able to intervene and be able to get them connected with the BCN if they had the dual diagnosis, and get them seen pretty quickly for an MOUD provider.
Thank
I
you
guess
so
I'll
much.
jumb in. Oh, sorry.
No, go ahead, Gary,
I
please.
haven't had much experience with ASWs as much as Aaron's had. The meetings that I have had with them, they seem to want to learn more about the things that we're doing and medications for opioid use disorder. And hopefully in the future with Jefferson County, we'll be able to get those referrals specifically from the ASWs, like you spoke about, Susannah. But I haven't had as much experience with them as Aaron has had.
Thank you both for weighing in. We really appreciate it. I think hearing the ins and outs of how it actually works is incredibly helpful. I think we're going to go back to Margaret, who's going to touch on SB 90 a bit and its context in the setting.
Thanks. Thanks, Gary and Aaron. So just to give you all a little bit more context for another program that is trying to do something similar to what Aaron and Gary were describing, with this kind of pre-sentence coordination, getting folks basically planned so that they can have this alternative sentence before they've even gone through the sentencing process and later elements of the criminal legal system. It's called the SB 90 Pilot Behavioral Health Conditional Dismissal Program. And this program was funded by our state opioid abatement funds, and it's run by the Administrative Office of the Courts and the Behavioral Health and Developmental and Intellectual Disabilities Commission in 10 different counties for 4 years. And each participating county and jail has access to MOUD, recovery services, and educational and vocational services. The statutory requirement of this program is that the jails that are participating must facilitate within 72 hours a clinical assessment for behavioral health disorders for people deemed by pretrial services to be low risk, low level by an assessor on a list prepared by the Cabinet for Health and Family Services. So think back to what we were talking about before in terms of some of these different kinds of delays, some of these different kinds of challenges. Jails are now required to make sure that within 72 hours of booking, a clinical assessment is done by one of these certified assessors for folks who have gone through that pretrial services interview and been deemed through their risk assessment to be low risk, low level. So really, when you think about it, Madison County Detention Center, with their request that Aaron talk with folks within 48 hours of their incarceration for that kind of assessment and referral process, is really kind of the pilot, leading the way for this pilot in a lot of ways. But to make this possible, what we know from our colleagues at the Administrative Office of the Courts Pretrial Services, and we talked about our overdose education and naloxone distribution program with them before, they have basically taken all of their organizational bandwidth to try to revise the way that they're collecting that interview data and create a database that it allows information to be shared with these different kinds of assessors. So it's been a real challenge to work with them in wave 2 because so much of their organizational bandwidth is dedicated to the system and transformational change required to be able to facilitate that 72-hour clinical assessment process. So as part of that, we are not doing any kind of linkage services or retention services with pretrial. And in wave one, we did have a pretrial a linkage program, but it's a really challenging way to be able to connect with folks given this kind of rapid turnaround. So we're hopeful that this becomes a model for other jails and that we have the opportunity to keep our recovery coaches and navigators in the jails that are actually doing this work already. So as you see with this third point, the assessment provided by these certified folks from the cabinet is required to supply recommendations to the court parties, so to the judge, to the prosecuting attorney, to the defense attorney within 48 hours. So compare that timeline with the timeline that we talked about in the context of those backed up court dockets, right? So really trying to facilitate this system change and get folks who need behavioral health treatment rather than criminal legal system involvement diverted through that pretrial process. But again, I want to underscore that this really took a huge lift for our administrative office of the courts to make this happen. And you can see a list of the participating counties here. So if you're from one of those counties or have those in your service areas, be aware of that. Kenton, Letcher, Madison, and Clark are the first to implement. And Administrative Office of the Courts is having different kinds of listening sessions around these implementations if you're interested in participating. Okay, time for another poll here. So let's pull up another poll. Everybody should see this question. Most prisons and jails offer medication treatment for opioid use disorder. I'll give it one more minute, but I think folks are converging around the correct answer here, perhaps from some of our context clues earlier. So I'll go ahead and share the results here. Hopefully you can see this. The answer is false. Most prisons and jails do not offer medication treatment for opioid use disorder, hence some of those complications I was talking about earlier with Mr. J's story here. So let's go ahead and talk a little bit more about the medications provided in Kentucky prisons and jails, in addition to what Susannah already said. So you see some of those points that she already covered, highlighted here in points 1 through 3. With the state prison program, Vivitrol is preferred, and that has been offered in the 8 prisons and 22 jails. Kenton County Detention Center is offering buprenorphine. And then we often see different kinds of limitations to pregnant women. That should not be pregnant, it should be pregnant women, and or pre-release Vivitrol or naltrexone, as opposed to offering the full complement of the 3 MOUDs. Concerns about diversion in facilities has limited use of the agonists and partial agonists, methadone and buprenorphine, despite ADA requirements. And that's something I want to go into a little bit more detail than what we heard from Dr. South before, specific to the criminal legal system setting. So in April 2022, the Department of Justice issued a guidance document to explain how the Americans with Disabilities Act protects people with OUD who are in treatment or recovery from discrimination in a number of settings, including employment, healthcare, and participation in government services and programs. The guidance document also announced settlements with drug courts and community supervision programs in Massachusetts and in Pennsylvania for discrimination against people with OUD and for limiting use of MOUD. So specific settlements in drug court and with community supervision there. In late 2022, a settlement was reached with the Lexington-Fayette Urban County Government's Department of Community Corrections to ensure that people who take medication to treat opioid use disorder can remain on their medication while in custody at the Fayette County Detention Center. The agreement resolves a U.S. Attorney's Office ADA compliance review of the Fayette County Detention Center, in which it determined that as a matter of policy, the facility did not provide most individuals with OUD with methadone and buprenorphine. The settlement agrees to require FCDC to revise its policies to provide access to all 3 forms of medication for people with OUD and ensure that determinations about treatment are based on an individualized decision by qualified medical personnel. So this is in a really important context for MOUD right now, that this ADA violation is one of the sticks available for our Department of Justice folks in pursuing compliance with the ADA requirements to provide MOUD in correctional facilities. And as Susannah alluded to, there are lots of different implementation models for medication treatment for opioid use disorder in Kentucky correctional facilities. Our Department of Corrections predominantly uses number 2 and number 3 to deliver the programs that are described in these bullet points here. And there's also a great deal of variation in Kentucky prisons and jails in terms of what methods and tools are used by medical providers to screen for OUD, different approaches to identifying and treating opioid withdrawal, and then reentry services provided before and the day of release here. Another poll for you all. What is the average annual cost of holding someone in a county jail? Right, I'm going to go ahead and end the poll, share the results. Got a range of different answers here. The correct answer is actually $34,000 or $34,000 a year for holding someone in county jail. So when you think about that cost of custody compared with the potential cost of actually providing treatment and getting folks out of that detention situation and preventing recidivism, really is from a cost effectiveness standpoint, there are a lot of studies of this too, really makes a lot of sense to be offering those medications for opioid use disorder, in addition to avoiding the potential of DOJ lawsuits and settlements. So I'll take it over to Susannah to talk a little bit about some of the challenges around reentry planning as folks are leaving a detention center where they may or may not have had access to medication treatment for opioid use disorder.
Thank you, Margaret. This first bullet point, the pre-sentencing and the variability there, I'm not going to focus on that much in discussing the ASW program and the adjudication process. I think we've given a sense of navigating that unpredictability and how we sort of coordinate around it. I'd like to focus instead on the reentry role that the CLS coaches and navigators play when they're working with participants and their connection to them for resources needed to prepare for release and successful entry or retention into treatment. As we discussed earlier with the broad overview of the programs, the recovery coaches and care navigators work in the jails to provide linkage services, offering support through case management, one-on-one coaching, building recovery capital, and providing education about MOUD and other treatment options. Throughout that process, they're able to identify existing or developing barriers to treatment, and they do a significant amount of reentry planning to ensure successful transitions to MOUD. Prior to release, they'll focus on procedural barriers, things like getting a cell phone lined up, a new state ID, social security cards, or preparing re-enrollment in Medicaid. Post-release, coaches and navigators will expand their scope and they'll help retain participants in treatment using HCS barrier relief funds to overcome large obstacles like transportation and housing assistance. Both of our partners, Voices of Hope and Bluegrass Care Navigators, have done an exceptional job in training their staff on how to identify and connect individuals to these and other important resources. Their creativity has been impressive. They've bought electric bikes, they've paid court fines, they've established partnerships with the local social security offices. I am just struggling with my words today to streamline receiving new cards. They've even supported getting other individuals who are incarcerated certified as peer specialists to be able to have employment upon release. I will say across the board, and I will continue this on the next slide, is the coaches and navigators' ability to recognize and respond to needs and identify practical solutions has probably been the biggest factor in our success in jails. As we continue into the next slide, we'll talk more about what that made that successful. Excuse me. But before we do, I want to lead off with another question that followed from session 1, and that was, while grant funding helps criminal legal system to fill in gaps for services, long-term sustainability plan is needed to adequately provide for these services. Are there any jails that have creatively developed long-term plans that are working well? And there's sort of two factors to answering this question. One is the financial component, and that one I don't have a clear answer to. There's abatement funding coming in at both the state and local levels, but more important, with these state level changes that we've been talking about, some of these will be mandated on the local agencies to change, and so that budget will be there and available. The local level does present more of a challenge, though. The budgets are not sort of the jailer's decision alone. They have to work with their county officials to make those decisions. And so it's not just the jailer that has to understand the importance of recovery support in an MOUD context, but those additional community members. And as you know, a lot of local level, there can be difficult dynamics. However, HCS has had the community coalitions that we've helped develop over the course of the study, and they've been instrumental in helping change perspectives within their counties, and their commitment to ongoing advocacy around these issues will help sustain the progress made. However, the one piece we can answer more strongly in terms of sustainability is organizational sustainability. Much of what is presented here on the slide and that you're going to hear from our Voices of Hope coaches in just a minute is about the adaptability throughout implementation and how that leads to an integration. They have melded the processes and methods to adapt to their partner's environment, creating processes that meet the needs of the agency and respond to their concerns. And that has enabled the jails and the other CLS agencies that are continuing these practices to really take them on as their own. I mentioned in our last session that that ownership is hugely important, and it is. It's our ultimate goal. We want these practices to become their practices, to be embedded with their staff, to be embedded with their intake, their booking processes, all of those things. So when it is not an outside entity being imposed upon them. And so no one can speak better than the people who've done this work. So you've heard from Aaron, who's going to rejoin us, and Gary. And I would also like to introduce Rebecca Gray, who's our recovery coach at Knox Detention Center. And then to lead them off with this discussion, we're going to bring back another one of last week's questions, which is, what have you found to be the best approach in changing hearts among the jail staff working in the criminal legal system?
Honestly, I use my training that Voices of Hope provided me. I used motivational interviewing to get to know the staff. Once I got to know them, I was able to develop trust and mutual respect between the both of us. And after that point, it was a little bit easier to self-disclose my own involvement using MOUD in my recovery. And after that point, you already have a level of trust and understanding between these people you're working side by side with. So they're able to see that, oh, wait, people can actually use this medication successfully. They can turn their life around. They can come in and help make our jobs easier. That's really honestly how I was able to make the biggest changes.
Yeah, for myself, like Rebecca said, we got a lot of additional trainings, and we're able to learn how to use MI statements and just learning how to interact with people. As you learn to adapt in recovery, like you learn how to interact and speak with people. And I think a lot of it relates with like action. So whenever you're putting forth your best work and you're doing what you can to help someone, it kind of shines through of what you're doing and the reflection of what you do. So like I've spent a lot of my time up front, like I don't go and be closed off or anything like that. I'm always out and proactive and talking with people within cells or within or just hanging out with the guards and just really getting to know them getting to know me. Like it's just been a really good experience for me because like they understand like, okay, like Rebecca said, this is a person that's making changes to be proactive in the community and helping others. And that's just really what it's based on, is just like really helping someone find a pathway that might work for them. For me, just having that interaction and just speaking from my experiences and sharing my story with them and them really getting to know who I am. I think that really took things a long way. And like Madison County was just so awesome. Like everybody within the jail, like I don't want to put any specific names on it, but one of my point of contact with Madison County, he is a person of recovery. I'm sure that he wouldn't mind me sharing that. So like having that interaction and that coincidence, you know, that we both come from a similar background. I think that helped us be able to interact and have great conversations and really get to know each other a lot better. Like I said, Madison County is just so proactive in the community and helping people find a pathway that might work for them so they don't keep reoccurring or coming back to the jail. It's just really great to just get to know them on both ends, I'm sure.
Speak a little bit about my what happened to me in the detention center. I tried to, first of all, this is one of the hardest things to do, is to win over the staff and to get them all on board with everything. But I try to get to know them as well. It start with the jailer, because once you can get the jailer on board, everything kind of trickles down a little bit to like the staff and the deputies and the jailers. So I would try to go to their staff meetings and just introduce myself. And I kept having to go just because most of the staff didn't know why I was there. So I kept going to the staff meetings, trying to train all the staff on OEND and MOUD just to make them more open about it. Because if they have the education and knowledge behind it, then they will be more open to these different avenues of recovery and what I'm actually there doing. But the benefit of like with the detention center I was at, and Rebecca and Aaron, is that they were open to change. So it kind of made it a lot easier because they wanted to change. They knew that there was things in the community that they could be doing better to help the community. And that's kind of how it made it so easy.
I'll just note that you guys have wonderfully given your agencies a lot of credit here, but your approach to building trust, to adapting to their processes, to spending time in their offices, working with their teams, it's that commitment to your agencies that also made a difference. So while I applaud our agency partners, I also applaud you as relationship builders, and all of our coaches and navigators. It's been absolutely phenomenal to see how you all approach these and address these issues. We're incredibly grateful for your work. And so Margaret, I will turn it back over to a slightly different tone and social service clinicians.
Great, great. And before I go on to the SSCs here, just of course, in addition to all the things that Aaron and Gary and Rebecca and Susannah have already talked about, there's this kind of flexibility. Part of that winning over hearts and minds is that we met the facilities where they were, right, in terms of what was feasible, what was possible, using detention center tablets for sharing information and promoting the program, as well as virtual coaching. In Madison County Detention Center, Aaron had full reign to go anywhere in that facility, like any of the staff members, which allowed him to be able to access personal property, drop that Narcan in folks' personal properties after doing the overdose education. And this kind of balance with security, right, where we had a background screening, walkie-talkie for coach safety to move throughout the facility here. And then this kind of sensitivity in variation in staff perspectives that everybody was talking about, combined with sensitivity to staffing considerations. They didn't have enough staff, and staffing issues post-pandemic have been an issue for every agency, but especially detention centers, given some of those factors I was talking about earlier. If a space wasn't available or the usual office space wasn't available, our coaches and our navigators adapt, right? Adapted the processes, adapted to what was happening in that facility there. And then one last thing I wanted to note here is that in addition to the educational components that Gary was talking about, a great way that we established for recruiting folks basically into these linkage programs, link people to treatment, was through SMART meetings offered actually within the facility. And I know Rebecca has done that, offered SMART meetings within the facility as kind of a way to begin the conversation with folks, establish those relationships, and then begin that one-on-one kind of work there. So before I moved on, I just wanted to see, Rebecca, did you, any of the Voices folks, anything about SMART meetings and how you use SMART meetings to kind of build those relationships that would be worth noting for our colleagues here?
I use the SMART incentives. That's kind of how I got people to engage with me in the detention center, because they didn't really trust me and they didn't really want to talk. But once they came back, and if you have a candy bar or something like that, like they're more willing and more apt to want to attend a SMART meeting. So those are some of the approaches that I used.
So I actually didn't even need to use incentives. Like for me, I remember when I was incarcerated, I was looking for every opportunity I could to get out of the jail, right, for my cell just for a few minutes. So like we would get to go outside, well, like in the rec room, and do SMART meetings, and we would also get to go upstairs and to the management meetings office and do SMART meetings and stuff like that. And so like it was really great opportunity. Like we would just really, a lot of times people were just wanting to be heard, right? So like we would do our SMART meetings, and they would just get to talk and vent and share a lot of their stories and ask me about mine. So it was really a great opportunity to have those SMART meetings, to build them relationships with the people that was incarcerated.
Thank you both so much. Rebecca, please.
The SMART meetings are great because I don't know the percentage of people who are incarcerated that have been exposed to some kind of a mutual help meeting, but it's really high. And the SMART meetings are structured totally different. It's not like anything they've ever been exposed to before, and it allows them the opportunity to take some agency over their lives and share some things that they normally wouldn't get the chance to share. It's a really, really great opportunity to get to see the light switch back on in people. And it really does happen inside of these smart meetings when you give them the freedom to talk back and forth between each other. It's a great opportunity, and that sometimes in itself, you sit back, I sit back, and I watch them interact with each other. That will give them the motivation to self-refer, to enroll in our program, and it's great.
That's beautiful, you all. Thank you so much for sharing those approaches to SMART. Great. Okay, so on to Intercept 5 and our sequential intercept models. We've talked about the ASW as that kind of parallel process. We've talked about what's happening in the actual jail facility, regardless of whether folks are sentenced or not. Now let's talk a little bit about the SSCs that run parallel to that probation and parole process we talked about last week. So those social service clinicians are providing, their role in some ways is very similar to what an ASW would do, with the exception of that court piece of it. They're providing therapeutic counseling, advocacy, and case management for adult offenders with the DOC Division of Addiction Services. So they fall under the Department of Corrections. They assist in the coordination of SUD treatment services with folks located in state correctional facilities or folks who are on probation parole. And they're responsible for screening, assessment, and treatment of clients with a validated substance use disorder, which includes participating in comprehensive treatment planning with their clients, interdisciplinary teams, facilitating treatment groups, and maintaining clear communication with other correctional staff and not directly involved with the substance abuse treatment, which of course is really important when you think about the ways in which treatment might intersect with some of the terms and conditions of probation and parole that we talked about last time. They are also a resource for staff, service providers, courts, and referral agencies. And they maintain confidential case records and have a requirement to be in compliance with substance abuse program licensure standards and comply with the Drug and Alcohol Counselors Code of Ethics and all correctional policies and procedures. We have 48 different social service clinicians assigned to probation and parole districts across the Commonwealth of Kentucky here. So we're going to switch quickly here to talk. So that's a little bit about the SSCs. We'll go into more detail on probation and parole because we talked about that last time, but they're that parallel clinical process to what's happening with probation and parole. So let's talk a little bit about how we interacted with the SSCs, Susannah.
Absolutely. Well, given the expertise and their sort of case management role that Margaret just described, from both DOC and HCS's perspective, SSCs were best positioned to identify and refer appropriate eligible participants from probation and parole. What they would do is in their case management process, they would review current clients taking medications for SUD, including their aftercare participants during Wave 2, and they would share information with eligible clients about recovery resources through VOH or BCN, and then they would refer interested clients to Voices of Hope. Working with the SECs, in addition to their sort of therapeutic counseling, nexus of expertise, it was also importantly a less intimidating point of contact for participants. We noted before that for individuals on the justice-involved individuals in the CLS, working with officers, discussing OUD, discussing MOUD, people are reticent to. This is an authoritative figure who has some measure of authority over their outcomes. And so having a case management professional that they could use as that point of contact obviously helps, overcome some of that deterrence. We did, however, still engage with those probation parole officers. They had materials and palm cards about recovery services that they would provide to participants, enabling participants to self-refer. But again, it was really wonderful to have that partnership with the SSCs as a case management point of referral. And then we're going to go back to Aaron once again. He had a great partnership with the SSC in Madison County. We'll just explain some of the dynamics in that partnership.
Yeah, again, like I mentioned earlier, so as we did our enrollment process, we would discover if they had OUD, if they had substance use disorder, and also maybe mental health diagnosis from previous experiences. And so we wanted to make sure that if that occurs, that they get back on their proper medications. Because I know for myself, I wasn't worried about what I was if I was on my proper medications, other things like that. So we would get them, I would get in contact with the SSC, which would be the BCN, and we would talk, and they would set up an appointment to come in to the Madison County Jail, and they would, talk with them. And like I said, there was a few instances like where people would be getting out, and we'd be able to. They was like one of my main point of contacts of connections or within the community, because they work right alongside a provider, so they would be able to work that person in as they're leaving the jail. So it was a great place for me to be able to step in and be like, hey, this person's about to get out, or can you work this person in? Can you come meet with this person? Like, it was a great opportunity to work with the SSCs, and they was very great. It was a very great experience to be able to work with them and have communication with them.
Thank you, Aaron. I know through Madison Jail, you experienced quite the range of interagency coordination that needed to be pulled off. One thing I'd like to note just before we move on to our next interception specialty court is that with both the ASWs and SSCs, and indeed many partners across the CLS system, I will not pretend there weren't bumps or obstacles in navigating these partnerships and setting up these collaborations. But for people interested in implementation or looking how to approach these strategies, they are very willing partners. I think a lot of the success is finding that everybody wants to do good work and support the individuals in these facilities and provide positive outcomes. And so while there are challenges, that shared goodwill and motivation, I think, overcame a lot of it.
Yeah. Also, I'd like to add, so I worked alongside, her name was Cassie, and she was so great. And she was constantly calling me, hey, what else? What do you got for me? You got anybody I need to talk to? So it was just a great experience to work with them, because communication is very great, and I love communication. It's very important to me. And they was constantly reaching out to me, so I was trying to make sure that if she did call me before I called her, that I had someone that she was able to speak with, you know what I mean? So.
That's awesome, Aaron. Thank you both so much. So I wanted to just briefly remind us what specialty court is. We have it at Intercept 3 through 5. We won't go to any detail here, so we have the majority of our time to talk about voices and experiences with specialty court. But just remembering that folks can be referred to specialty court at adjudication during that kind of pre-sentencing process, with pretrial diversion or in lieu of incarceration, or after release as a condition of probation. And specialty court, drug court is determined, eligibility is determined through staff administration of an eligibility assessment, which is a modified version of the ASI. And then the judge ultimately determines admissibility. Folks who are participating in specialty court programs and drug court have 5 stages that and phases that they need to go through, with lots of different requirements for meetings with staff of the drug court, as well as judges attending the court hearings, obtaining employment, urine screens, living in appropriate housing, paying court agreements, and enrolling in attending self-help programs of different kinds. So what I want to quickly do a poll here. This is important context for specialty court. Judges in specialty court programs must allow participants to pursue MOUD treatment. Is that true or false? Okay, I'll go ahead and end the poll and share the results. We were 50-50, true or false. So the answer is unfortunately false. Judges in specialty court programs must allow participants to pursue MOUD treatment is false. Although it is consistent with all these best practices, ADA, we know from the ADA settlement that specialty court and drug court denying MOUD access was something that caused a settlement, but as a matter of practice, there aren't a lot of enforcement mechanisms for those judges in specialty court programs. In Kentucky, as Susannah said, there's a reform initiative underway under Supreme Court order, where our administrative office at the courts are working at the state level with local programs to try to bring folks into compliance with national drug court standards that openly accept, of course, all MOUD treatment as indicated by clinical providers, but this is a reform effort that is ongoing. So let's finish off with some more conversation about what specialty court practice looked like for voices and our implementation.
So that poll sort of leads us to our major point here. We discussed the partnership during the OEND session, highlighting the state and local level leadership roles and how they've impacted our partnership. We've been really fortunate to have that state level buy-in, support and encouragement. And then at the local level, they made the ultimate decision, though, about whether or not to partner with HCS on both OEND and MOUD strategies. So for that MOUD implementation, we maintain that same partnership structure, but where OEND is something operationalized outside of the courtroom, providing recovery services to drug court participants obviously necessitates entering into the judge's sort of dominion in that courtroom. And they have become a somewhat silent partner. And as the poll was indicating, they don't have to allow MOUD treatment. And so with that role of ultimately determining who can participate in drug court and the terms of any release related to it, their perspectives on OUD and MOUD play a significant role in how impactful we're able to be with those participants. In the same regard, the provision of recovery services can also be affected by the prosecuting attorney's stance on MOUD and their willingness to allow participants to be diverted to treatment of any kind. So all of these things, we have this partnership with the staff, they can be as every bit as engaged, but that courtroom environment and their perspectives on it are really what's going to shape the ability to engage with participants. However, and continuing our line of success stories, during wave one, we had a specialty court partnership in Fayette County that was tremendously successful. And Gary was our former recovery coach there and now program coordinator. And we've asked him to share some of his experiences and the factors that made that impact possible. Gary?
Thanks, Susannah. So like Susannah was saying, it was very successful, but they allowed me to be able to kind of have free range in there. They were very open to my ideas and thoughts and the way that I went about things and my suggestions. They included me in staff meetings. So things started slow at first, but they included me in staff meetings and the lunches that they would have and different things like that. And like they would allow me to go in the judges' chambers and speak with the judges and allow me to put the input that I had on the participants they were speaking about. To kind of advocate for the participants, to give them a different kind of point of view. They strategically placed me on the floor with the recovery coordinator, so I was able to work with them hand in hand. So if someone came to their recovery coordinator and said that, hey, I'm having trouble with housing or this, or I just need someone to talk to or meetings, my office was right next door and they would just refer them and to come right in and speak to me. So that made it easy for me to have those referrals and to build the relationship with those participants. And it worked out really well. And with that, like it was one of the most fulfilling roles that I've had here at Voices of Hope. I got to sit with judges in their chambers, which is strange for me, and laugh and joke with them. And like you don't see them like as real people, when they're like on the other side of you when you're in the courtroom. But like when you get to see them in their chambers without their robe and talk like human beings, and they speak to you like you're on the same level as them. It was very empowering for me, and that was like one of my favorite parts about the specialty court placement. And with that, I know the poll said that they don't have to let them be on MOUD, but all the judges in Fayette County were supportive of MOUD. The judges, the prosecutors, everyone was on board. So it was very helpful to the participants, and it was able to help me do my job a little better. If someone was trying to told the judge that they wanted to get on medications for opioid use disorder or any type of treatment, they would make them come and speak with me after court. And they would just come over and speak with me, and I could help them get linked to medications, or if they just wanted to go to treatment in general, I could refer them to treatment and different things like that.
Awesome, Gary. Thank you so much for sharing that. And that program continues, right, with another coach in that placement, right?
Yes.
Wonderful. That's awesome. So with our last 5 minutes here, we'd love to open the floor for any questions that folks have, especially questions related to our attempts at answering your questions from the last time around.
I'll ask a question, even though I know the answer. I think it's a really great experience. Erin, I know in Madison jail that there was sort of a discussion with leadership, and there was an expectation goal setting process that went through that sort of really integrated with you staff. Could you talk about that a little bit, please?
What are you? Can you help me understand what?
My understanding is they set like clear expectations about OEND and what their goals were with providing recovery support services, and that really helped drive your engagement and staff commitment.
Yeah, so like whenever someone was incarcerated, they wanted all of their people who've been incarcerated, they wanted everyone to have Narcan and be educated on how to use it. Because unfortunately, a lot of times people continue use when they leave the jail and they think they can go back to using the same amount they was using, and a lot of people experience overdoses. So they wanted people to be educated, also putting vending machines. So like they was very, like I said earlier, say like 70% of people get re-released back out, and they wanted me to really focus on the people that was coming in and being in detox and trying to get them, encourage them in some kind of different pathway that might work for them. So they was very mind strong on that part of the process, and having them with all the tools that they may need when they leave, in case they might go back out to use. There might be that chance where they're going to go back out to use, making sure that they have the information and the tools that they may need if they decide they want to come back, or like get a hold of me outside of there and maybe go to treatment or get linked to medication, wherever that might work for them. That was really great process, and I really enjoyed that part of it. That having that clear, constructive pathway of like, hey, this is what we want you to do. That really helps me engage better and really focus on what areas I need to focus on with people that was coming in.
Thanks so much, Aaron and Susannah. And I would just want to, before I turn it back to Chris and Lisa here to close us out, of course, be in contact with me and Susannah. You'll have our email addresses if you do have any questions you want to follow up on. But I want to thank, of course, our co-presenters and everybody in this Zoom room, from the implementation facilitators to the other recovery coaches, and Sam and Tasha, our stalwart artists formerly known as BCNs because of those insurance issues I was talking about before. We are so grateful for all of the learning that we've done together about how to be effective in these criminal legal system settings with diverting folks to the treatment that they need and deserve. Thank you all so much for everything we've presented today has been our collective learning together. And back to you, Lisa and Chris.